community property is one of those topics that bleeds into a bunch of different areas, into wills and trusts, into torts in terms of remedies. So remedies, there's a lot of different areas, contracts. Community property is not a silo topic, right? Because most people you're dealing with will be married. This is a area of law where even if you never do family law and divorces, you need to know community property. Okay, community property. So start off your essay with community property presumption. Okay, the community property, California is a community property state. Right? The community property presumption is that assets acquired during marriage are community property, and assets owned either before marriage or obtained during marriage by gift, will, and inheritance, or afterwards is separate property. So the presumption is assets acquired during marriage is community property, and that stuff you got before you were married or by gift, will, in other words, intestate succession. There was no, will means obviously with the will, and inheritance means intestate succession when there was no will, probate. So gift, will, or by the probate process. I guess you could have probate even with the will. I don't want to confuse you, but all of those things are presumptively community property. Okay. Community property, the assets acquired during marriage are community property if they are acquired during the economic community. There's a slight difference between marriage and economic community. Okay? And the difference is when a couple is still married but they're separated. So if a couple separates, their wages are no longer community property. They might not have filed for divorce yet. So what's the definition of the ending of the economic community? Permanent physical separation and intent not to resume the marital relation. So, wife moves out, I'm sick of this, and moves out. She doesn't file for divorce for 6 months, a year. But the moment she moves out and tells the husband, I'm done, even if she hasn't filed for divorce, his wages after that are no longer community property. Okay, and neither are hers. So now it's separate property. Okay, so it usually coincides with marriage, but it doesn't have to be. If there's a separation, then the community property is also done. Okay, how do you distribute community property on divorce? Community property is divided evenly on divorce, and there's a disparity. Each individual community asset and liability is divided equally. Each individual community asset and liability. So what you got and what you owe is divided equally. Okay? Or it's divided pro rata, right? Equally. Disparity among the earning power only matters as to liabilities, but not necessarily as to assets. Okay, so it doesn't matter that husband is a millionaire and wife was stay at home. He still gets half the money. And it's not an argument to say, but he already makes a bunch of money. It's irrelevant. You get half and half. Okay, so when you take into account, well, she can't earn as much money as he can because she hasn't had a job for the past 30 years. Well, you take that into account for splitting up debts, but not for splitting up stuff, assets. Okay. Community property can be divided non-pro rata. That is, an asset is awarded wholly to one spouse. Okay. And the other spouse receives assets of equal value under certain circumstances. So under certain circumstances, instead of selling that item and dividing up the money, you can give the entirety of that item to one spouse and giving something else of equal value, like a trade-off, to the other spouse. And the circumstances where you do that is in family residence. If there's minor children, usually it's awarded entirely to the spouse that has the majority of custody, right? That retains the kids. to avoid uprooting the children. So if there's minor children and husband leaves, then the house is awarded to the wife and husband receives that amount that he lost on half the house, that amount in other assets. You know, a proportionally higher amount out of the bank account or whatever. So that's one exception to the pro rata rule. Family residence. 2, closely held corporation. Right? If you had a family business, we're not going to necessarily make you sell the business and give half the value of the sale. You award the business to the managing spouse, whoever was in charge of the day-to-day, and then the other spouse gets assets of equal value from other places. Okay? And then finally, pension. A pension is usually awarded to the earning spouse, and the other spouse receives a proportionally greater share of other assets. So family residence, so home, corporation, and pension, closely held corporation. Okay. A couple of statutory exceptions. A spouse can receive more than 50% of the community property if the other spouse, 1, misappropriates community property before or during the marriage. Okay? If the other spouse, how do you misappropriate community property? You give it as a gift, for example. We're going to talk about that in a bit. Neither spouse is allowed to give a gift of community property without the other spouse's written consent. Now, that happens all the time. So where the written consent comes in is if there was not written consent, the other spouse can take it back. Okay? So if you misappropriate community property, if you incur, here's another one, a spouse can receive more than 50% community property if the other spouse incurs educational debt. All of us. If you incur educational debt, the non-educational debt spouse can receive more than 50%. And then tort liability. If there's tort liability not based on activity for the community. If the other spouse, so the spouse that gets more than 50% is the innocent spouse, the spouse that did some tortious act, and it wasn't for the community. For example, it was a car accident, but he wasn't shopping for groceries. He was going to see his girlfriend, a la Tiger Woods. Right? In that case, then the innocent spouse can get more than 50% of community property. If there's a tort that wasn't based on community activity. Okay. Also, a personal injury award. Married couple, one of them gets injured, gets a award. That money is community property, but it goes to the injured spouse. Usually that money is going to go to the injured. It's not going to be split between the non-injured spouse and the injured spouse. Okay. If community liabilities, what if the couple owes more than it has? If community liabilities exceed assets, then the liabilities are apportioned considering the ability of each to pay, because we want to protect creditors. Okay. So you split debts based on earning power so that the people who earn more owe more, so that creditors can get paid back. Okay. During your life, can you make gifts, during the marriage, can you make gifts of community property? The answer is no. Neither spouse can make a lifetime gift without the other's written consent. Okay? So, because the right to manage belongs to both spouses, if there is an inter vivos gift without the other spouse's consent, then the other spouse can take it back. The right to manage does not mean the right to give away. It means the right to invest, the right to make something out of it, but not give it away. That's not managing. Okay? During marriage, so what happens, and they like to test this on the bar because it's a simple issue. During marriage, the non-consenting party sets the gift aside in its entirety. So the spouse has said, why'd you give that away? Can get it back completely. After the divorce, the non-consenting spouse gets 1/2 of it back. Can set the gift aside as to 1/2 of interest in the community property. You shouldn't have given it away. During marriage, I have the right to manage it all, so I can yank it back. But after marriage, I only have the right to 1/2 of it. Right? My half, what would have been my community property share. Okay? And you can recover from the donor. So where do you get, after the divorce, let's say the husband gives the car away, gives his Rolls Royce away just to spite the wife. or right before the divorce. He knows she's going to fight divorce, and just to spite her, he gives the Rolls Royce away. So he doesn't have to give her half the price. That happens all the time. People give away valuable assets for nothing just to stick it to the other party. Okay? It's like, I don't need the money, I don't care. Fine, here, you get your $5 from the Rolls Royce. Okay? What can she do after it? She can get half of the actual value, so whatever, $200,000, half of the actual value, but the guy drove off with it. So you're not going to find the buyer, and the buyer, assuming it was a good faith purchase, which that $10 Rolls Royce probably wasn't, but assuming you can't find the guy, where do you get the half back? From him. Yeah. So you can get it from the donor, from the spouse who gave it away without permission, or you can get it from the donee. Good luck if you can find him.
So who would you go after first, the donee or the donor?
There's not really an order. It's whoever you can find.
Oh, really?
Yeah.
Okay. Thank you.
Usually the donor is the easiest to find because there's already a court process. Right. So you just say, okay, instead of giving you half, I'm going to give you a lot less because I'm accounting for that thing you gave away.
Okay.
So there was an example on a 2014 bar exam on this. By the way, community property is tested almost every single bar exam.
Yeah, why is that?
Almost every single time. Because they want to, I think it's because they want to root out non-California attorneys.
Oh,
yeah, so community property, some California-specific thing is tested all the time. It's never just going to be the evidence, torts, contracts, stuff that everybody, no. There's almost always going to be at least one community property, at least one wills and trusts, or California evidence. Yeah, or California Civ Pro, or yeah. So this is very common. The stuff here is very common, and they're not going to get too deep into the weeds. The kind of stuff they ask on community property tests is like, if you don't know, you shouldn't be a lawyer. It's basic stuff. It's like stuff that they gave away. Okay, I can get it back. Sorry. I will get into the nitty-gritty to help you understand it, but don't stress too much about it. The questions they ask are not.
Yeah, actually, that was my highest essay, and
yeah.
I don't understand why.
Yeah, because they ask pretty general essays. Is he allowed to give away the property? No.
I don't understand.
Husband owns a cabin he got from his uncle. He inherited from his uncle. Is it community property? Let me think about it. No.
Yeah.
Right. So they're that kind of questions. Okay. However, I'll give you as broad as possible in the next 3 hours, 3.5 hours. Okay. What about a testamentary gift? So a lifetime gift is you give it away during your life. Testamentary gift is when I die, you can have it. A testamentary gift to community property. Each spouse can devise, that means given a will, all of his separate property and 1/2 of his community property. Okay? So any gift of community property that's greater than 1/2, what can the non-consenting spouse do? So can husband and wife own a house together? Can the husband say in his will, the house goes to my friend when I die?
No.
Okay, yeah. So he can force a sale of the house, and the friend gets half the value, but he can't say the house goes, right? So he can give all of his separate property, all the money I inherited from my mom goes to my friend. That's fine, he can do that. Yeah?
Can the friend then say, refute that and still get half, or is it because he wasn't specific and didn't clarify the details of what he's giving?
Well, so here's what happens. It's not what the friend does, it's what the wife does, or the other spouse. During the testator's life, the other spouse can void the gift entirely. In other words, the other spouse can invalidate the other one's will. If wife finds out about husband's will that says everything goes to my friend, she can invalidate the entire will. Okay? However, or that gift in the will. What about after, but more likely it's going to happen after he dies. So here's, I say, community property, you have to know for wills and trusts, you have to know for remedies, you have to know some for contracts, some for torts. This is a subject that has roots everywhere else. After the testator dies, that's usually when she's going to find out about the secret will, saying that everything goes to friend. What can she do? She can recover half of her community property. Let's say he gets the whole house. She can make him give half of the value back. And she recovers either from the friend, the donee, or from the spouse's estate. Okay? And if you're thinking, well, wait a minute, she has everything the spousal estate already has. Well, not necessarily, because what if it's a blended marriage, right? And he was previously married and there's a lot of separate property. So he can get from the spouse's estate. In other words, his kids, instead of getting all of his separate property, she can recover half of the house that she was supposed to get from the donee. Okay? It's the same result of a third party is named as beneficiary of community property, of a community property life insurance policy. So there's life insurance policy, the premiums with which you pay the life insurance, if the premiums are paid from your wages, the whole policy is community property. So what if husband names his mom as beneficiary, not his wife? But he paid the premiums with his salary, which is community property. What can the wife do when the husband dies and the mom gets all the money? Because the life insurance company is not going to fight you. They're just going to send it to whoever's on the beneficiary. So they're just going to write a check to mom. Wife finds out, oh, wait a minute, you had life insurance. How come I didn't get anything? She probably finds out months later, oh, mom, my mother-in-law got it all. Well, what can she do? She can recover her half interest in the benefit from the beneficiary, from mother-in-law, or from the husband's estate. So again, from donee or donor. So the main idea here is during their life you get it back, after the death you get half of it back. Okay, and you can get it back either from the recipient, or you can get it back from the estate of the spouse. Okay. Another option is the widow's election. Widow's election. If a spouse attempts to devise an entire interest in a community property asset, or includes an explicit widow's election clause. So what is a widow or widower? It's usually called widow's election because husbands tend to die first. What can the wife do? So let's say the husband says all of the house worth $500,000 goes to friend, but all of the insurance policy, which by the way, I pay the premiums out of my inheritance money and not out of community property, so the insurance policy is completely separate property, and it's worth $10 million, all of that goes to wife. What can she do? So what if, well, she can either take under the will and say, well, I'd rather get the 10 million insurance policy than half the value of the house.
It's more than true.
Yeah. So you take under the will and you let the other guy have what he shouldn't have been able to get, right? Because they're only allowed half of the asset of community property and he got it all. So she can take under the will, she can accept the testamentary gift and allow her community property interest to be disposed of per the will. Or two, she can take against the will. She can forfeit the testamentary gift. Nope, I'm not going to get the life insurance policy because it's only $100,000. Okay? I'm going to assert my half interest in the house. But you can't have your cake and eat it too. You choose one or the other.
Well, we get points docked if we're like on the essay and we're like frazzled and we're like, okay, too much thinking, let me just pick one or the other and not try to go through it. Like, I mean, because clearly we should pick the one that's going to get for 10 million.
Exactly. So you say both options, mm-hmm. and then you just say, here, she probably do this one because it'll give her more money.
Oh.
Yeah. But yeah, basically, if a will does not respect community property law and gives somebody else an entire asset, the wife can say, forget the will, I'm taking what's supposed to go to me. Or the wife can say, sure, I'll take by the will because I get more. Mm-hmm. Right? Instead of his kids from the previous marriage getting that, I get it. Okay, never mind, I'll go by the will.
Okay.
But the point is you can't have your cake and eat it too. You can't both take under the will and take half of the community property asset. You choose one or the other. Okay, what about you purchase something on a credit card during marriage? Okay? Financial troubles tend to be one of the leading causes of divorce. People getting into debt and blaming each other for debt. So credit card purchases during marriage. Funds borrowed during marriage are presumptive community property. Money you got that's borrowed, just like wages are presumptively community property, borrowed money is presumptively community property, and goods purchased with that borrowed money is presumptively community property. Goods purchased during marriage. Okay? And what counts? How do you know whether a funds borrowed, credit card purchases, how do you know whether that is community property or not? You look at the primary intent of the lender. Was the lender relying on the spouse's credit score? Yes, 99% of the time. Well, guess what your credit score is? A community asset. If you're married, your credit score is like your salary, is like it's a community asset, assuming it was largely built during the marriage. Like most people start with nothing, and they live in an apartment for 4 years, and then so if, however, the intent of the lender was not to rely on the credit score, but to rely on some other collateral that one of the spouses puts up. Hey, I know my credit score sucks, but here, I'll sign over I'll give you the pink slip to my Rolls Royce that I got inherited from my mom. Now those funds are no longer community property, that purchase. So look at the intent of the lender. And if they're relying on credit score, and there's a long-term marriage, most likely the credit score is itself community property. Okay, what are the fiduciary duties of each spouse? Each spouse owes the other, by virtue of the confidential relationship, fiduciary duties, which require the highest good of faith and fair dealing. Highest good faith and fair dealing. Okay, so there's good faith and fair dealing among spouses. If one spouse gains an advantage, there's a presumption of undue influence. Okay? And if one spouse is grossly negligent or reckless investment, there's also a breach of the duty. Okay? Grossly negligent doesn't just mean you bought shoes and you didn't need to buy shoes. You don't need your 30th pair of shoes, right? Grossly, I guess it could be that, but grossly negligent is, you invest in something that's obviously dumb. I'm going to invest in sending time capsules to Mars. Give me $1 million to it. Okay. I'm going to invest in illegal activity, right? I'm going to buy drugs and sell them. That would be gross negligence, reckless investment. Okay. Can you have an agreement to alter the nature of your assets from community or regular? Yes. So a premarital agreement. How do prenups work? How does a premarital agreement work? Premarital agreements to change the character of assets must be, 1, in writing. They have to be in writing. 2, signed by both parties. Okay. And then the exception requires 2 elements. Unless what? So in writing, signed by both, unless the oral agreement is already executed. Let's say there was just an oral agreement before they got married, and afterwards it was already executed. Okay? And it was executed by the promisor, right? The person who promised, hey, I'm going to give you half of my separate property. You know what? I know I inherited all this money, but I want you to have half of it. Okay? And so how does he execute that oral promise? By putting it in a joint bank account, right? Because then she legally has access to half of it. So then there's a divorce. Then can she say, and he wants it all back. Let's say there's a divorce, he wants it all back. Hey, it was separate property, I get it all back. Well, she can say, normally the rule is in writing, signed by both. Here, the oral agreement was already executed, right? The promisor, you promised to give me half of your separate property, or to let me, and you put it in a joint bank account. So, okay, and how do you show it? The promisor spouse's conduct indicates an agreement. Okay, and then so one is already has to be executed, and the promisee has to detrimentally rely. It's in the bank account, and now the promisee quits her job because, hey, I got a bunch of money. So there has to be some, not just that he does something to back up what he said, but that she does something to rely on it. Okay, writing signed by both unless executed reliance. Executed by the promisor, relied on by the promisee. Okay. What is a defense to a premarital agreement? How do you get out of a prenup? Let's say there really was a written prenup signed by both. How do you get out of a prenup? Okay, if you prove that it's involuntary. How do you prove a prenup is involuntary? Okay, a premarital agreement, on the bar don't call it a prenup, call it a premarital agreement. A premarital agreement is deemed involuntary. So the default is it's involuntary. Unless So the rule is it's involuntary unless you can prove these things. Okay? The default is we don't like those agreements unless the spouse challenging the premarital agreement was, one, represented by separate counsel. Okay? So she can't get out of the prenup, or he can't get out of the prenup, if they were represented by separate counsel. Two, they were given at least 7 days to sign before the marriage. And they expressly waived the right to counsel. So there's no prenups on the way to the altar. At least 7 days, and if the other spouse does not have their own attorney, they have to expressly waive it. And third, the spouse challenging it was fully informed in writing in a language she was proficient in. If there is a dual cultural marriage and things in English, okay, and she took 3 years of English in high school and that's it, okay, doesn't quite work. And fully informed in writing in a language she was proficient in of the terms and basic effects of the agreement. Okay? So it's involuntary unless the spouse challenging it had a separate attorney, 7 days to sign it before the marriage, and knew exactly what the other guy had. Fully informed in writing. Okay. Another way to challenge a premarital agreement, one, that it's involuntary. Two, that it's unconscionable. Okay? A premarital agreement is that waives spousal support. If we ever get divorced, I don't have to pay you anything. That's right. It smells fishy from the beginning. Well, that kind of agreement is not enforceable if the spouse did not have independent legal counsel, or if the premarital agreement is unconscionable when it's enforced. So this is the one, remember unconscionability in contracts? It's unconscionability in contracts is substantive unconscionability, right? The terms are oppressive. Procedural unconscionability, the way you got there, the back and forth between the parties, the negotiation is oppressive. I'm calling you at 11 at night. Hey, want to do this? Okay, quick, bye. Screaming over you, hanging up. It's in a language you barely understand. It's, I have an attorney, you don't, right? So there's substantive and procedural. But in contracts, the kind of unconscionability that matters is when the contract is entered into. Not when it's going to be carried out and people don't like the deal they made. With premarital agreements, it's the opposite. It's the only place where the unconscionability that matters is not when they got into it. Let's say she knew exactly, it wasn't unfair, it wasn't oppressive when they did it, but when it's enforced, she's dirt poor and he's a millionaire. And he says, we have an agreement that there's no spousal support. No, it's not going to be enforced. It's unconscionable when it's enforced. So just think of that difference. Not unconscionable when entered into, like most other contracts, when you care about unconscionability. It's unconscionable when it's enforced. Okay. The premarital agreement affects any other. Okay, another way to make it unconscionable is if the premarital agreement affects any other risks. Let's see here. Any other, if I can read my writing. Okay, premarital agreement is not enforceable if the spouse did not have full and fair disclosure, any other rights. Sorry, it's a right. Any other rights. A premarital agreement is not enforceable, welcome, if the spouse did not have full and fair disclosure of the other spouse's assets and liabilities. Right? How am I supposed to agree to not getting something when I didn't know he was a millionaire? I just thought he had $1,000 from his mom. Okay? Did not, and the right to disclose. So you have to have full and fair disclosure. Can you still enforce a premarital agreement that did not fully disclose? Yes, but it has to have these two things. The right to disclose has to be waived in writing, and the spouse has to have adequate knowledge already. Like, I already know what he has, you don't have to write it down. And I'm going to write on the contract, you don't have to tell me because I already know. Okay, so one more time. The premarital agreement is not enforceable if 1 and 2 and 3. 1, there was no full and fair disclosure. And 2, the right to disclose was not waived in writing. And 3, the spouse had no adequate knowledge of assets and liabilities. So again, how do you get out of premarital agreements? If they're involuntary unless there was separate counsel 7 days before the wedding. And if there wasn't separate counsel, there was expressly waived, and the other spouse was fully informed. Okay? And if it's unconscionable of spousal support, and the unconscionability when enforced. Okay, that's a premarital agreement. So how about marital agreements? During the marriage, changing the nature of assets. Okay? If you ever do trusts for people and they put a house into a common trust, that has the effect of making it community property, even if one spouse bought it before the marriage. Okay? So how do you change the nature of an asset during the marriage? Okay? This is called a transmutation. A transmutation means changing the nature of asset from community to separate, separate to community. Before 1985, it was okay to have an oral transmutation. Honey, we can have it now. I know I got this from Uncle Joe, but here, it's for us. Okay. After 1985, transmutation must be in writing. 1. 2, signed by the adversely affected spouse, the one who's giving up the interest. Okay. And 3, explicitly states that a change in ownership is made. A writing signed by the adversely affected spouse that explicitly states that a change in ownership is made. So for example, you're putting a house that one spouse bought in their own name, and then there's a marriage, maybe later in life, or there was a second marriage, and then you put it into a trust. Well, it's going to be a writing, obviously. It's signed by both parties. It has to be signed by the person who had the house before, and it's going to state a change of ownership from Joe as a single man to Joe and Martha as trustees of the Smith Family Trust. Okay? Exceptions. A gift of tangible personal property. So that is not substantial in value when compared to the circumstances of a marriage, and used primarily by the donee spouse. A gift from where? A gift between spouses. So remember, you have to change the character of an asset, you have to have a gift in writing. Sorry, you have to have a in writing signed by both parties, by the adversely affected spouse, and says that ownership is changing. What if one spouse gives the other spouse a gift? Well, gifts are always what? Separate or community? Separate. Gifts are separate. So if I give my wife a ring, that is a separate property. Even though I bought it with community property funds, it's now separate property. Okay? However, for that to be true, it has to be tangible personal property. If I give her stock certificates, that doesn't work. It is not her separate property if it's between spouses. Now, if her uncle gives her stock certificates, then it is her separate property. But if I do, and I bought it with community property funds, it's community property. Okay? So a gift of tangible personal property. 1. 2, not substantial in value when compared to the circumstances of the marriage. Are they a poor couple? Are they living on the federal poverty level of what, $14,000 a year? Well, a $1,000 ring, that's substantial. Okay? So that might not qualify. That might still be community property. Are they, both professionals making 6 figures? Then it's probably not substantial. So you look at how rich the couple is to determine whether a gift between spouses makes it community or separate. Why do you care? Because inevitably in these stories there's a divorce, and the guy wants it back. I gave you that ring, it was community property, take the ring off your finger, sell it, and give me half the value. Okay? So what happens? She's going to say, no, it was a gift. It changed it. He's going to say, but we're poor. Right? We're poor, it was substantial in value, so the gift exception didn't work. So look at, if you're having trouble memorizing all these rules, think of who would argue it. Who's going to say this stuff, right? So the person that wants to keep it is going to say it's all their separate property. And the person that wants half of it back is going to say it's community property. Okay, so tangible personal property, not substantial in value compared to the circumstances of the marriage, and used primarily by the donee spouse. I don't go around wearing her rings. Okay? What if it's like a painting that you hang up in the living room? I think that was a bar exam question. Something like that, or a statue. Yeah? It's like, well, the painting, and the spouse wasn't, it was like, they made like $25,000 a year together. Right? So it was like, well, it was a gift. He said, honey, I've got this for you. You love art. Let's put it in our living room. Well, likely, I mean, you argue, but say, well, it's probably substantial in value compared to their marriage if they're poor. Second, it's not primarily used by her, it's in the living room. Now, what if it was in her bathroom, right? Over her side of the mirror. That'd be one thing, but if it's in the living room, probably not.
And in that case, do they sell it and then split the proceeds?
Yeah.
Okay.
Yeah. Or they can make some agreement with the, that's the default. And you can always make agreements in the divorce case where you say, okay, you keep it all, then you give me half the value for something else. But the default, if no agreement is made, if they, I'm not talking to her at all, then you sell it all and you split. Okay, you sell each individual item and you split the money. The judge doesn't go around saying, oh, the painting's worth $1,000, the car is worth $1,000, you take the painting, you take the car. No, everything's sold and money split, unless there's an agreement between each side's lawyers usually. Okay, what about title to property? Okay, title to property. If the title is in joint and equal form, okay, so now we're going to talk about Lucas and anti-Lucas. Lucas, marriage of Lucas was the 1985 case. Okay. This applies when the marriage is terminated by the death of either spouse. Lucas applies to somebody's a widow or a widower. It does not apply to divorce. Lucas applies to death. Luke, I am your father. Just think of that. Okay, Lucas only applies to death. Does not apply to divorce. Only applies to death. Does not apply to divorce. Only applies to death. Lucas. Marriage of Lucas, the case said, it holds that the form of title controls. The form of title controls. A spouse who contributes separate property to property titled in joint and equal form. What's the most common property titled in joint and equal form? A house. Usually it's going to be in both of their names. But they build a back room with the husband's inheritance money. He's contributed separate property to a property that's joint in equal form, the house. What happens? The spouse who contributes separate property to property title in joint and equal form does not retain a separate property ownership interest. A spouse who can, so the house is husband and wife together, okay? Money that he got is inheritance, okay? Inheritance, and it's husband's separate property. He's going to add it to the house, and now it's a house with a back house, okay? So he's contributed his money to double the size of the house.
Yeah.
It's a blended marriage. He's got his own kids. What do his kids want? He dies. What did his kids want? His kids going to all want all of his separate property, right? Say, stepmom, you get the community property, but we get whatever he came into the marriage with. He came into the marriage with all that money, and we know where it went. It went to building the back house. Right. So therefore, we get the value. Sell your property. We get the value of the back house. Okay? That's what they want, but they're not going to get it. Because that's what the marriage of Lucas case was about. It says that spouse who contributes separate property to property titled in joint and equal form does not retain a separate property ownership interest. But remember, it applies to death. In other words, the spouse's kids. It does not apply to divorce. It applies to death.
So that's if he dies.
If he dies, what do his kids get? Because Well, they don't get that anymore. Yeah, because now it's community property.
Oh, okay, but if he didn't die and they divorced, then they get
Yeah.
Okay, got it.
So it applies to death only, and the spouse retains it. Why do we care about him? He's dead. We care about his kids, and usually think second marriages. Okay. A spouse who contributes separate property to property title in joint and equal form does not retain a separate property ownership interest and has no claim for reimbursement. His kids don't get to say, stepmom, if you want to keep it, you give us half the value. You give us back the $30,000 he put in.
Yeah.
No. Okay.
He's dead.
A gift to community property is presumed, and the donor spouse can establish there was an agreement to retain unless, so a gift to community property is presumed, unless the donor spouse can establish there was an agreement to retain a separate property interest.
Okay.
If there was some writing saying, I'm giving us the money,
Yeah.
but I'm keeping it a separate property, and if I die, my kids get it back.
Okay.
Okay? Absent a written agreement, it's a gift to community property. His kids don't get it. Now, that was the case. The legislature didn't like that a lot, so they wrote anti-Lucas statutes. Okay? So this now applies when marriage is terminated by divorce, because the case basically said everything. The case didn't distinguish between death and divorce, right? It's marriage of Lucas. Any case that starts with marriage of is a divorce case, right? So Lucas was a divorce case, and it was a broad general, the black letter law to that case is when you give separate property to community property, it's a gift and you don't get it back. Then the legislature came out with anti-Lucas statutes, say, okay, but in case of divorce, okay, if one spouse contributed separate property towards the purchase and improvement, property title in joint and equal form is presumptively community property, even if one spouse contributed a separate property towards purchase or improvement. So in divorce, the presumption is still, okay, it's community property, even the amount that he put in. It's a gift. But now he can rebut it. It's not about his kids now, because now it's him, it's a divorce. He can rebut that presumption that it's all community property and doesn't get anything back. How? If there was an express statement in a deed or a separate written agreement that the property is partly separate property. So let's say when they do put the house in a trust, they don't say as joint owners of a trust, right? They say husband and wife as trustees with a 50% interest in the house, and husband in his sole capacity with a 50% interest, right? Let's say there's something in the deed that tells people this is not all together, okay? And the spouse can be reimbursed without interest for his contributions to DIP. So if there's something in writing, the husband who gave it, or wife, whoever gave separate property to community property, after divorce can get it back, but it's dollar for dollar. There's no interest. We don't say, well, that was 20 years ago and at 4% per year. No, it's dollar for dollar. You get it back. What do you get back for? Contributions to DIP, down payment, improvements, and principal payment on the mortgage. Down payment, improvements. So improvements would be building the back house. Principal payment on mortgage. Okay. And if you think about it, these two are the same. Goes towards the cost of the house. You don't get back what you paid in interest to the bank on the mortgage. You only get back what you paid to make the house more expensive or to take away from the actual principal amount of the loan. Okay? So if the community property test is a divorce test and not a death test, if it's a divorce test and one spouse contributed separate property towards community property, it presumptively stays community property, unless there's some written statement that it was intended to be partly separate property. And if there is, then that spouse can be reimbursed, but no interest. Dollar for dollar, and only for these things exactly. You are not reimbursed for mortgage payments or anything like that. Okay? Welcome. What are some actions that, so that's the anti-Lucas statutes. What are some actions that change the character of property? What if you use community property to pay debt on your own separate, property? So, let's do this situation here. Husband and wife, okay? Husband bought a car before he was married, and he still owes money on it. He bought it with his own credit rate before he was his own credit score before he was married, right? So it's separate property. That's separate liability, separate property asset. Okay. However, then they get married, and then the husband goes to work, and husband uses community property to pay off the car. Okay? In that situation where you are using community property, your salary, to pay off something you bought before you were married, separate property. Spouse has made an installment purchase before, so this is what happens. When spouse makes an installment purchase before marriage, think of a car, but the debt is being paid with community property after the marriage, the community takes a pro rata interest equal to the percentage of the principal debt paid by the community. So, he bought a car for $3,000. Yeah, I'll make it more realistic. $30,000, and his credit score was horrible, so 10% interest. Okay, so every year he had.
California, you probably about $300,000.
Yeah, exactly. So he has to pay $3,000 on top of his. So a 5-year loan, $30,000 divided by 60 months would be $500. No, right? $500 a month. So $500 a month if it was 0% interest, right? But it's not 0% interest. It's $500 a month plus $3,000 a year divided by 12 months would be about $260. Okay, so now he pays $720 a month. Okay, so let's say the wife they get married, and now his salary, which is now community property, he uses his salary to pay off that debt. And then there's a divorce. What does she get? What interest in the car does she get? Can you just say, well, hey, asset during marriage, car, therefore you get it, split half and half? Well, no, because he had it before he was married. So what do? The community gets the amount of interest that the community has in the car is the amount of the principal debt. So let's say he gets married, and 4 years later the divorce, and now that he still owes $10,000. At divorce, he owes $10,000. Okay, and let's say he bought it like a week before he got married, so he didn't actually make payments on it until he got married. But the debt was incurred on his own credit score, so it was separate property. So what does the community get? $20,000. So the community gets how much of the down payment? We don't care about the interest, only the down payment, only the value of the asset, the amount of the loan. The community gets how much they paid on it, and he gets the rest. So if the car is sold, okay, so $20,000 is community property. Well, but it's out of 30, right? So 2/3, right? 2/3 is community property, 1/3 is separate property. But on the bar exam, they will not ask you, what percentage is community property, what percentage is separate property? They will ask you, then you only then have to work, what does husband get? And what does wife get? So don't stop there. If you answer there, you're not answering the question. Husband gets his third plus half of the community property.
Okay, I'm kind of lost.
Okay, sure. And as we do these formulas, it's tempting to stop the calculation when you say community this, separate that.
Okay.
But that's not the call of the question.
Right.
The call of the question is, what does husband get, what does wife get?
Right.
At the end of the day, how big is the check? Okay. So in this case, the community paid off 2/3 of the value of the asset.
Right.
At divorce, how much does each get?
Half.
No, because he bought it before he was married. He bought the car before marriage. If he bought it during marriage, then yeah, of course.
Oh, yeah.
So if he bought the car before he was married on his own credit score, which means it was not a community asset.
Right. But he didn't pay anything until he started got married, though.
Yes. So let's say he didn't. They even if they didn't pay anything until they got married.
Yeah.
But it was his separate property.
Okay.
The car is a separate property.
Okay.
It's a separate liability. The liability was incurred. The debt was incurred before marriage.
Right.
Okay. The community paid it down to $10,000.
Right. So they paid $20,000.
$20,000 off the car,
Right.
plus a bunch of interest.
Okay. So then $10,000 belongs back to him, right?
No. The way it works is you take what percentage of the value of the asset, of the value of the debt, was paid for by the community.
Okay. In this case, 2/3.
2/3. So the community paid 2/3.
Yes.
Okay. So the community gets 2/3 back.
Okay.
But don't stop there because you're going to get the question wrong.
Okay.
What they want to know is how much does wife get? Wife gets half of that.
Right.
She gets 1/3. Husband gets 1/3.
Up to 20,000.
No, whatever the value of the car is when they sell the car.
Whatever the value of the car.
Yeah, because the car is probably going to be depreciated by then.
But what, the 10,000 that's left over, like who's paying that?
It was his debt to
So
begin
he's
with.
paid, right?
Yeah.
So he pays that, and then
Yeah.
the value.
So that means he's going to get a proportional 1/3 extra in the value of the car.
Okay, so if he takes on the 10,000, but let's say they sell it for, I don't know, 15,000, she would only get 1/3, 5,000.
She gets 5,000, he gets 10,000. Because remember, he's still got to pay the 10,000 debt.
Right. Okay.
Okay,
Yes.
so she gets half the community property and he gets half the community property plus what was left over. So he gets 2/3 and she gets 1/3.
Okay, now I get it.
Okay?
Take a picture of that.
Absolutely. Now you might want to discuss what the picture means soon because you look at those numbers tomorrow and be like, what was he talking about?
Yes.
Okay.
Thank you. And now it makes sense. I totally get it now.
Okay. One more time.
Thank you.
What you look at is what percentage of the asset was paid for by the community. That percentage belongs to the community. Now, community means both. So you split up that percentage, right, husband and wife, and then the other percent that wasn't yet bought by the community is still by the spouse that had the asset beforehand. Okay. What if you use community property? So this one was using community property to pay debt on your separate property. What if you use community property to improve separate property? So instead of a car that he owns on, that he inherited outright, mortgage-free, a cottage from grandma. Okay, so he inherits a cottage from grandma, and husband has it as separate property, and then they get married. And then he uses his salary to fix the roof, to build another bathroom. He uses his salary to improve separate property. What percentage does she gain an interest in that separate property? And to what extent? That's the question. When community property is used to improve separate property, the community does not gain an interest. Okay, the community does not. So here, when community property is used to pay debt on separate property, the community gains an interest because she's helping buy it.
Right.
Here, she's not helping buy it. It's for improving it, not to pay the mortgage on it. So the community does not gain an interest. It's a straight up reimbursement. She can get the money back. Okay? of course, half the money back. The community means she gets half the money back, okay? And the community does not gain an interest in that separate property, but the community is reimbursed by the, reimbursed for the community property expenditures. Now, there's two ways to reimburse the community. The greater of these two things. So let's say it was a horrible, cottage with broken, looked like a haunted house. Okay, nothing was there. He fixes it up with community property, with his wages, with her wages. He fixes it up with community property, and now it's this gorgeous thing they can do like Airbnb in. Okay, so then there's a divorce. What does she get? What is the community reimbursed by? She gets half of the community's reimbursement. What is the community reimbursed by? The greater of two things. So you look at, let's say this was worth only $50,000 when he got it, because it was in really bad shape. And after they used his salary to fix it up, now it's worth $200,000. After community property is used to improve it, not to pay the debt, but to improve it. What can the community be reimbursed for? Oh, and by the way, how much community property was used? Probably another $50,000 in money to pay contractors, let's say. So, what does the community get back? The greater of the money spent to fix up the place, or the increase in value. So the community gets back $50,000 or $150,000. Obviously, they're going to go for the $150,000. That's what the community gets, not what each get. So at the end of the day, okay, there's a divorce. The cottage is sold for $200,000. But the wife says it's not fair. The only reason it can be worth so much is because you paid to fix it up out of my salary, out of your salary, stuff you got during marriage. So it's not fair that you get to keep all $200,000 of it. The place was a piece of junk when we got married and you inherited it. Okay? So the community would either get the $50,000 or would get the $150,000 difference. Okay? Don't stop the question there, you'll get it wrong. That's what the community gets. The question is, what does she get? She gets $75,000. Right? And he gets $75,000 plus the original $50,000. Right? How much it was worth at the beginning. He'll get $125,000. So husband would get that, wife would get that. Okay? To take a step back, when community property is used to improve separate property, the community does not gain a proportional interest as it would when you're paying debt. All the community gets is straight up reimbursement, and you're reimbursed dollar for dollar by the greater of the actual money spent, community expenditures, or how much a separate property increased in value, the increase in separate property's value. Okay, so situation one, separate community property to pay debt, a separate property. Situation two, community property to improve separate property. So paying debt, improving separate property. Situation number three, community property to improve the other spouse's separate property. So here you're using community property to improve your own. What if you use community property to improve the other spouse's separate property, and there's a split of authority? Split of authority as to whether community gains a reimbursement. Now, this is California. How do you have a split of authority? Different courts of appeal. The LA district versus the Orange County versus San Francisco. Okay. I don't think you have to go there. It's usually just do this rule, right? They get a reimbursement when community property is used to improve separate property. There's a reimbursement depending on how much money or the increase in value. Okay. What happens when accounts are commingled? Commingling on its own does not transform separate property into community property. The simple act of putting the money in a joint bank account does not make it, or putting wages into your separate bank account that you have only in your name. Okay? The simple act of doing that, right, commingling community with separate, separate with community, does not change the nature of the property. However, the spouse wishing to claim a separate property interest in assets purchased from a commingled account cannot use recapitulation. I'll say that one more time. Just because you put the money in a joint bank account, so husband puts inheritance in husband and wife's joint bank account. They buy a Cadillac with that money. Now, let's say there was only like $5,000 in the account, and he puts in $40,000. They buy a $30,000 Cadillac, very used one, I guess, for $30,000. How much does he get back? Does he get back what? I put in 30, I get back 30. Well, he cannot use recapitulation. He has to overcome the family expense presumption. And the family expense presumption is this, that family expenses were paid for by community property. Okay, what is recapitulation? Recapitulation is trying to show that family expenses exceeded community property funds. Hey, that car was for the family, but I bought it with separate property, so I get it back. It's a family expense. Okay, the family expense presumption is that family expenses are paid for by community property. So the husband wanted to get the entire $30,000 back that he put in. He has to show that he has to overcome the presumption that all family expenses are paid by community property. The spouse wishing to assert a separate property interest can use exhaustion or direct tracing. Exhaustion is saying there was no community property available when the asset was acquired. There was zero in the bank account. I put in $30,000, we bought a $30,000 car. Voila, where do you think it came from? Okay, so if there was exhaustion, there was no community funds, then you can say I have even though we bought the car for us, it's separate property because I used all my separate money. Okay? Or direct tracing. And direct tracing is quick in, quick out. I put in $30,000, there was $10,000 already in it. I put in 30, the next day bought a car for 30. Where do you think it came from? Right? So direct tracing, quick in, quick out. If you put in 30 and next year you buy a $30,000 car, you can't say, well, I put in that 30, I want it back. No. Okay? Because the presumption is family expenses are paid for by community property. So the only way you get your money back if you put separate property into a community joint account is if there was nothing in there in the beginning, exhaustion, or it's quick in, quick out, direct tracing. Okay. Now we're going to talk about businesses. Van Camp and Pereira, my favorite. Van Camp and Pereira. If a business increases in value, okay, so think of a situation where a couple has a business, or one of the spouses, let's say the wife is an accountant and she has her own accounting firm. And she does so-so when they get married, but she does really well for herself over the next 15 years, and then there's a divorce. What happens? Okay, when a business dramatically increases in value. Okay. So there are two. Yes, you're right. Did it increase in value because of the spouse's effort, or because of it's a good business to be in? So how do you decide which way the assets are split? Okay, so Van Camp and Pereira. Okay, and the way you decide it is Van Camp, if it was a very lucrative lucrative, it's kind of stretched mnemonic, but it works for me. Very lucrative enterprise. That kind of business, like you were in real estate in 2007. Any idiot could have made $100,000 in real estate in 2007. Okay? Of course, they promptly lost it in 2008, but. All right. So if you were in a very lucrative enterprise, you use the Van Camp method. If it was because of personal labor and skill, you use the Pereira method. Personal labor and skill. Okay? Now here you have awkward situations in divorce proceedings where the wife says, he's a genius. I can't stand him, but he's a genius. He works so hard, he's so smart, of course it's personal labor. And the husband says, no, I'm an idiot. I just got in the right business. I don't know anything. I don't know the first thing about business. So the husband badmouths himself and the wife says he's a genius. Right? Because it's a different formula. So under Van Camp, if it's just a good business to be in at the right time, you value the community labor and the rest of the business as separate property. You value the community labor, the rest is separate property. That's the short version of the formula, then I'll explain. Okay? Value community labor. In other words, what would somebody in that position make if they weren't working for themselves? If they're working for somebody else, what would their salary be? An accountant, right? If you were in real estate, then it was you were in a really good position. Well, what would a broker make in 2007? Okay, you value the community as if you worked for a bank, if you worked for Century 21. Okay, what would that person make? That's his salary. Everything else, so that's community. Everything else is separate property. Welcome. Okay. All else is separate property. So real quick to review what we're talking about businesses that grow in value, right? You get married and then at divorce, the business is much bigger. There's two ways to divvy it up. The Van Camp method, you use it if you just were in a good business at a good time. Very lucrative Van Camp, very lucrative business, okay? You just were in the right place at the right time. Real estate, whatever, 2007. Pereira is personal labor and skill. Personal labor and skill, okay? So under Van Camp, you look at what would somebody make in that position if you were hired by somebody else. That's the market salary. So what is the community property interest? Under Van Camp, community property interest market salary. Let's pretend you weren't in business for yourself. If you were working for somebody else, what would somebody in your position make? Okay? So the community property says, okay, we're going to have the market salary and minus, because remember the community got paid out of that, family expenses, minus family expenses paid. So of course, the husband, let's say the husband was in real estate. He's going to look around and say, he's going to look for the cheapest possible salary. Oh, I know a guy who only was making $50,000. Okay, and I spent $45,000 a year on our stuff. So guess what the community property interest is? $5,000. I get $2,500, you get $2,500, bye. And the rest, $200,000 of the value of my brokerage firm now, is separate property that he gets to keep, right? So community property interest, market salary minus family expenses, rest is SP, sorry. So let's say the business is valued at $1 million. Okay? 10-year marriage. So let's just keep things simple. 10-year marriage, $1 million business. Okay? The market salary was $100,000 a year. Okay? So he's going to say, okay, $100,000 a year, 10 years, that's $1 million. Community property interest, minus everything we paid for. Well, you had expensive tastes for the 50 pairs of shoes. So we, let's say I spent $70,000 a year on family expenses. Therefore, the community interest is only $30,000. Okay, $30,000 a year times 10, 300,000, right? 10-year marriage. $300,000 is community. I keep 150, you keep 150. Oh, and by the way, the other 700,000, that's mine. So in this case, under Van Camp, the person who owned the business makes off like a bandit. He gets 850,000, she gets 150. Right? So if that's just the kind of, you were just in a good business at the right time, okay? So again, be careful. The question is not community versus separate. The question is husband versus wife, right? Do you want me to write those numbers here? Would it be helpful to write the example? Okay. So, and the bar will do that. They're going to keep the numbers pretty straightforward. You don't have to be a mathematician here. Okay. 10-year marriage. The business is valued at $1 million. The market salary, I'll put it MS, market salary is $100,000 a year. Okay? So what's the community property interest? 100,000 times 10, $1 million. Okay? But family expenses paid. How much, how much did we pay to upkeep our lifestyle? Well, let's say 80,000 a year was paid. Only 20,000 was put in savings. 80,000 a year was paid to keep our lifestyle. So what's the community property interest? So family expenses, 80,000. What's the community property interest? CP interest, 20,000 times 10, 200,000. Right, 20,000 a year. Right, $200,000 is the community property interest. Separate property, and the rest is as separate property. So community property interest, 200,000. Separate property interest, 800,000. So let's say husband was the broker. He was the real estate person. Okay, and then husband gets all of separate property plus half of community property, 1/2 of CP, which is 100,000. So husband gets 900,000, the value of the business when it's sold. Wife gets 100,000. Okay? You see why the husband would want to argue, I was an idiot, I just got in the right business at the right time. Okay? Of course, the wife is going to say, no, you're a genius. You knew exactly where to invest. You hired the perfect people. You did all the, I saw you doing those spreadsheets at 11 o'clock at night. Right? It's personal labor and skill. Yeah?
Can you work it out again?
Sure. Under the Van Camp?
Yes.
Okay. Business was worth nothing when they got married because it was just started. 10 years later, it's worth $1 million. Okay? So the business is worth $1 million. How do you divide up the assets of the business at divorce? Or let's say they didn't start the business until they were already married, right? This is not necessarily stuff that you already had before you were married. So they started the business during marriage. How do you divide up the assets? Okay, actually, sorry, no, this only works if the business was had before marriage. I was wrong. If the business was had before marriage and then they get married and they the business grows. So let's say there's $1 million is the growth. If not the actual value of the growth, let's say it was worth 100,000, now it's $1.1 million. So whatever the growth and value of the business, okay, that's what we're concerned about splitting. Because the original value he gets anyway, it's a separate property, it was before marriage, okay? So we're concerned about what's the growth in the marriage, who gets what? The growth in the value of the asset being a business, okay? The way, if the court finds that it didn't grow because he's so smart and he works so hard, it grew because he struck gold. He happened to get in the right business at the right time, okay? The way it's divided up is you value the community labor, everything else is separate property. The community property interest is the market salary, right? Market salary minus family expenses. We're going to pretend that he wasn't working for himself, that he was working for somebody else. How much would a real estate broker in that situation make per year? Well, you look around at comparable salaries. Let's say that over 10 years, it was $100,000 a year. Let's say it was $100,000 a year was the reasonable market salary. So the community property interest is $100,000 times 10-year marriage, $1 million. But you subtract family expenses. Because what I want to know is, what does the community get out of it? And the community shouldn't get out of it twice. If they already got out of it by stuff paid for, right, you subtract it. So let's say it's $100,000 market salary per year minus $80,000 of family expenses per year, right? So you have market salary $100,000, family expenses $80,000. That leaves a community property interest of $20,000 per year times 10-year marriage. The community property interest is $200,000. So the value of the asset is $1 million. The community property gets $200,000. Okay. So what does husband get? He gets all of the separate property, $800,000, plus half of the community property. So the community property is $200. He gets $100. So he gets $800 plus $100. He gets $900. Wife gets $100. It's a really lopsided formula. Yeah.
That's if the business was in existence prior to the
Yeah. I'm not clear on that. I'm not clear on that. I think so. I have to look that up. If generally on the bar, they're going to make it kind of obvious, okay, that he struck gold. Or if it's not obvious, you do both formulas and you say likely under this formula he gets this, under that formula he gets something else. Likely the court would find that this formula was used because it was a really good investment time. Okay, what if the wife succeeds in convincing the court, no, he was a genius. He did all the spreadsheets. He hired all the right managers. He fixed up all the right houses. I watched him see that Flip Your House TV show, 3 a.m. He knows what to do. Okay, so what do you do if it's Pereira? The separate property interest is the capital investment. Yeah, you're right. I think both of these are, the business existed before the marriage. Separate property interest is the capital investment, the value of the business before the marriage, plus a 10% rate of return per year. The rest is community property. Okay. Separate property interest is capital investment. That means value of business at marriage. Right? Because the whole value of the business at marriage was a separate property. So what did the separate property put into that business? The value at marriage plus 10% rate per year, right? Rate of return, 10% rate of return per year, 10% of that original value, okay? And the rest is community property. So see how this works here? Under Van Camp, you figure out what community is and the rest is SP. Under Pereira, you flip it. You figure out what the separate property is and the rest is community. Okay? So let's say the business was worth $100,000 when they got married and it grew to $1 million. How much does the owning spouse, let's say the husband had the business, they got married, and at divorce 10 years later, it grew to $1 million. What is the separate property interest in the $1 million business? The $100,000 plus 10% of $100,000 is $10,000. 10,000 times 10 years, another 100. So now the separate property interest would be $200,000. The community would be $800. Okay, so I'll write the example out here. Business worth $100,000 at marriage. Okay, after 10 years, it's worth $1 million. Okay, what is a separate property? And it's because he was so smart, because he did all the work. He hired all the right people. It's his own personal labor and skill. The separate property interest is $100,000 times 10% per year times number of years. Right? 10% per year is $10,000 times 10 years. And the bar will give you easy numbers like that. Okay? So that's another 100,000. 10 times 10. Another 100,000. So the separate property interest is $200,000. Community property interest is $800,000. Remember, just the rest is CP. The question, of course, is not separate versus community. The question is husband versus wife. Husband gets what? Separate property plus half of community. 200 plus 400. Husband gets 600, wife gets 4. Husband gets 9, wife gets 1. Big difference. If it's because he struck gold, he gets 9, she gets 1. If it's because he worked so hard, he gets 6, 2 plus 4. He gets 6, she gets 4. Okay, so she gets 4 times the amount, and he loses 300,000.
So how does it make sense to me? Like, he puts in his labor and effort. Like,
Because your labor and effort is community.
oh yeah.
It's a community asset.
It's like a come up with the man.
Yeah.
So what's the, what's $200,000?
Your hard work and your sweat while you're married is the property of the community.
That's right. Okay.
Well,
Yeah.
Sorry, one more time. Where did $200,000 come from?
The 200,000 is the worth of the business at the marriage was 100,000.
Okay.
Then you get 10% rate of return.
Okay.
10,000 times 10 years, another 100,000.
Thank you. It's so helpful.
That's Pereira. Okay, but if you forget all that, just think Pereira is start with separate plus 10%, everything else is CP, community. Van Camp, start with community, which is market salary minus expenses paid. Everything else is SP. Right? Let's take a break. Okay, welcome back. Community property, part 2. Pensions. What do you do with pensions that were earned during the marriage, and who gets it at divorce? One of the sad parts of the community property textbook is a lot of the cases are like these 30-year marriages. You think, oh, divorce. You think like, people got married at 18 and divorced at 21. Unfortunately, a lot of the cases, if they had enough property to be worth getting into a book, they were, many-year marriages, so they're retired in the divorce. Who gets the retirement money? So, pension benefits are considered, it depends, so pension benefits in general are considered deferred compensation. Deferred compensation. Okay? So, pension benefits are community property to the extent accrued during the marriage. The community has a pro rata interest equal to years of service while married divided by total years employed. I will explain. Okay. Let's say there was the pension, so we'll keep the numbers simple. 10-year marriage, and at the end of the marriage, he gets, so he's already working. So husband is already working at factory. Okay? He's starting to build up a pension. Okay? So he's working at factory for 10 years before marriage. Okay, before the marriage. Then there's the marriage. He works at factory for another 10 years. Okay, then there's a divorce. And he gets at the pension, as a result of those 20 years of working there, let's say he gets $50,000 a year in pension from the company. Not a lot of companies do pensions anymore, so what does wife get?
1/3.
Okay, she gets half of what?
10 years.
Half of 10 years. So if $50,000 pension was earned over 10 years during the marriage and 10 years before the marriage, she gets half. So $25,000 was earned during the marriage, and she gets half of that, $12,500. Okay. No, it's a fourth. Okay. Well, don't think of fractions like that. Just think whatever percentage of the pension was earned during the marriage is community property. And then each spouse will get half of the community property. So the community has a pro rata interest equal to the years of service while married divided by the total years of employment. So community property interest in pension equals years of employment while married divided by total years of employment. The percentage of time that, don't get too stuck in the math or the formula, just you got this money because you worked a long time, but most of the time that you worked, you were married. Therefore, half of that. Let's say this was 30 years and this was 10 years. Okay? And at the end of 30 years, he gets a, let's say, $80,000 pension. At the end of 40 years of the job, he gets an $80,000 pension. What does the community get? How much does the community, what is the community property interest in that pension? Okay, exactly. So the community property interest is 30 divided by 40. 30 divided by 40, that's community property interest. That's 3/4. So the community property gets 3/4 of 80,000. If you remember from algebra class, of is always an x, multiply, right? 3/4 of 80,000, 3/4 times 80,000, right? So the community gets 60. The husband gets, so separate property is 20. That means the husband gets separate property plus half the community. Husband gets 50,000 out of the pension, the wife will get 30,000 out of the pension. Even though she never worked at the factory at all. But because most of the pension was earned during the marriage. Okay?
She was working at home.
She was definitely working at home. Okay?
That's right.
So that's how, that's the cool thing about California community property law, is that it recognizes that a marriage is marriage, and we're not going to be like, well, how many potatoes did you peel? Right? We're not going to get into those details of how hard did you work.
How many diapers you changed?
Yeah, how many diapers you changed? Well, I change diapers Mondays and Tuesdays. No, if you're married, all of your sweat and labor during the marriage is community asset. Okay? So she could be eating chips and watching soap operas all day long. They're married. Yeah, well, the nanny does everything. Yeah. So if it's considered deferred compensation. Now, if you're familiar with pensions, you don't earn the pension, you're not entitled to it the moment you start working. They have to vest,
Right.
which means you have to work there for a certain number of years before you're entitled to get anything. So, what if the benefits have not even vested? Let's say that we'll do one more example. 10 years marriage. 10 years before marriage, he works at the factory. 5 years into the marriage, then at the factory for another 5 years, then there's divorce.
Okay.
The problem is the pension doesn't vest till 20 years.
Okay.
Okay? So what happens if the divorce happens before he's entitled to anything, before vesting? If the working spouse is not eligible for retirement, the other spouse can either wait until it is received and get half of the community property share. So the non-working spouse can just wait for another 5 years and then get half the pension, or whatever, half the community property share in that pension. So let's say there's another 5 years of work after the divorce, and then there's retirement, and then he gets $100,000 a year. Very generous company. Okay, what is the community property interest? 5 divided by 20, 1/4. So the community property gets 5 over 20, which equals 1/4 times 100,000. Community property, right, will get 12, we'll get, the community will get 25,000. That means the non-working spouse gets 12,500, the working spouse gets the 12,500 plus the rest.
We really have to do all this on the bar. I don't remember this.
No, probably not.
Okay.
They might get into those details, but they like to ask pretty general questions.
Okay. This is giving me a headache.
No, like, for those of you that loved math, which is why you went to law school, don't do the formulas. Don't be too stressed by the formulas. Think intuitively. She deserves the amount that was earned during the marriage.
Right. That's easy.
Okay? So, if 3/4 of that pension you got because you were married while you were earning that,
Right.
I get 3/4. The community, not she, the community gets 3/4 of the pension. If you were married 5 years of the 20 years, the community gets 1/4 of it.
Okay.
Okay? The community gets whatever was worked during the community, during the marriage. Okay. So if they have vested, the non-working spouse has two choices. They can wait till it vests. Basically, the divorce case is never closed. The judge has jurisdiction, and 5 years later they go back to court. Okay, now he got it. Now give me whatever. Or the spouse can be cashed out and get an equivalent value now. Let's say the spouse doesn't want to wait 5 years. I don't want to deal with you again ever in my life.
What's usually the preference?
It depends how well they get along, right? If it's like, I never want to see your face again, I don't want to come back to court in 5 years. So what do? They said, just give me the value now. You're going to get 100,000 in 5 years. So right now, we're going to pretend that you're retiring right now. Right now, give me 25,000 times your life expectancy.
And where do they get the money from?
From other assets he has. Now, if he doesn't have those other assets, then she has no choice but to wait.
Oh, got it.
But if he has separate property or whatever. So they have a choice. What if the benefits have vested and the husband doesn't want to retire?
Is it the point of time of divorce?
Yeah. So they divorce, the husband doesn't want to retire, doesn't want to you only get a pension if you retire. What if the husband doesn't want to retire? But they have vested. He's entitled to retire but doesn't want to. The other spouse can receive the benefits now. So the other spouse can say forced retirement or pay me out of other stuff. You don't have other stuff, guess what? You're retiring.
Oh, she
They can
retire?
either make him retire and get it, or if you don't want to retire, then pay me out of other stuff you have. And if you don't have that other stuff, then you have to retire.
Really?
Yeah.
A judge can order him.
But that's his livelihood.
Well-
Forward.
He's got a pension.
Wow.
Yeah, so the judge can either say you have to retire and get that pension to give her half, or absent that, pay her what she would have gotten from other stuff you have. If you have separate property, if you have your own secret bank account in the Swiss Alps, pay her out of that. But if you don't have that stuff, it's all you have is a 9 to 5, then retire. Moral to the story: stay married.
Get married.
Well, no. It's actually
Very wisely.
Mary Wise. It's actually the single largest. Yeah, the single largest contributor. Eric Fitzgerald he's a professor here. And he teaches family law. He's like, I never encourage my clients to divorce. That's what he does all day. Because I don't encourage them to divorce. It said it's going to make you poor. It's going to be hard. But sometimes you have to. Sometimes, like I'm dealing with a domestic violence case. Like,
No, exactly.
what am I going to tell her? Stay married? No.
It's cheaper to keep her. Sorry, you did.
I've never heard that.
Oh, yeah, but I said it's cheaper to keep her.
That's so funny.
Or you upgrade her so that she gets taken off the market faster.
Wait,
I
what?
had somebody who bought like their ex just a new makeover, so that she would attract a new.
What?
Yeah, because once they're
Once they're married.
once they're married,
Making her look
spousal support applies till they get married again.
Right, I
So
see.
she can
Wow,
get something new,
that's wrong.
so that he does not have to.
That's like-
That's
support.
just
Once you
crazy.
get married to somebody else, you lose that.
That's not
May I
right.
ask
Yeah.
So what happens if I was gonna say either get married, don't get married,
Mhm.
or keep it a keeper, or, you can just get married, but you're not registered.
Good question. In California, so common law marriage does not exist in California.
I know that, yes.
So it doesn't count.
But even if they're married, like, for let's say 34 years, and they have a certificate from the pastor, but they forgot to actually register.
They're not married.
They're not married?
They're not married. No rights.
But when do the rights become effective? Once they register?
Yeah.
But okay.
So
Wow.
that actually happened to a family member.
It happened to some
They went to church, they got the marriage, they lost the paperwork, they never turned it in.
Yeah.
It's like, we've been living together for 10 years and we were married. Seriously.
But do they start it at the time of?
They didn't know, obviously, but.
Can they go back?
Oh. Probably, because that case yes, there is a, it's called putative spouse. Yes. Yes, when there was a good faith belief in the marriage, yes.
Okay.
Yeah.
Interesting.
So disability. What about disability benefits? Disability benefits are not deferred compensation. They are wage replacements. Okay, so they are classified by when they are received, not when they are earned. Disability benefits are classified by when they are received. So if you are no longer married, when you get your disability benefit, the ex gets nothing, right? If you're married, then you get disabled, and then 5 years into your disability, then there's a divorce. Well, all the disability benefits gained during the marriage are community property, because it's wage replacement, and all the disability benefits after the divorce are separate property. It's not like pension. Just think of it as wages. Okay. Severance pay, where the golden handshake. We're going to fire you, but here's $60,000 to hold you over till you find another job. If it's considered a wage replacement, then it's separate property. If it's the result of a collective bargaining agreement, if it's part of the contract that workers who get fired or laid off get severance pay, then it's community property, because you got into that work based on that agreement, so it's community property. Okay. So if it's a severance pay, just look at, was it part of the agreement, or was it part of the, or was it a wage replacement? Okay.
I have a quick question.
Yeah.
You say wage replacement because I thought that once you're in the marriage,
Yeah. So what if the point is that what if there is a divorce and then he gets fired and laid off?
Okay.
He gets fired and laid off after the divorce,
Okay.
and then he gets a huge chunk of change. Can she get any of it?
No.
If it's severance pay, no, because it's considered wage replacement. But even if the layoff and the severance pay occurs after the marriage, but he was able to get it because he worked at that company during the marriage, and the severance pay was not the boss just being generous, a one-off. It was part of the contract,
Which attaches to
his work during the marriage. Therefore, she gets a community property interest in that severance pay.
Got it. Okay.
So just look at, was it part of the contract or part of or the boss is being generous? Generous boss, separate property, part of the contract, community property. Okay, stock options. Whether stock options are community separate, what's a stock option, by the way? It's where the company gives you, my brother-in-law has this at his company. It's the only reason I'm like, that's an example. Basically where the company says, we are growing, we are going to give you the option to buy stock at a set price, 50 cents a share, let's say. Even if in 10 years, stock is worth $100 a share, you get to buy it at 50 cents a share. Now what's the point? Not so you can, I have 50 cents. You buy it and you sell it immediately and you made all the profit, right? You buy it, you sell it the next minute, and you made all the profit in one day. But the stock option is an option to buy stock in your own company at a super cheap rate. So whether that option is separate or community property depends on the primary intent of the employer. If it's a reward for past services, hey, congratulations, because you've worked here for 10 years, because you have worked here for 10 years, there's a past tense thing in there, you get on your, at the ceremony giving you the plaque, you get a plaque and the stock option. Then the community property interest is determined by the number of years employed during the marriage divided by the number of years employed till the stock option can be exercised. So, till the stock option can be exercised. So, stock options. Okay? If it's a reward for past labor, congratulations, thank you for working here for 10 years. And to show our appreciation, you get this plaque and you get option to buy stock at 50 cents a share. Okay? If it's a reward, then that should tell you ding, 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 community property. He worked during the marriage. Okay? Then it's community property has a pro rata. That means a proportional share equal to number of years. Let me see here. Employed while married divided by number of years. Now before, the denominator before was just how many years employed altogether. Here it's because that's what counted before you could get retired and get your pension. Now it's how many years employed, how many years does it take before you earn the stock option? Number of years of employment before stock option is earned. Okay? So, husband works at the factory for 5 years. Then he gets married, works at the factory for another 5 years. Then gets divorced. Okay? And gets divorced after 10 years of the factory. 5 years of those years he was married. He gets a stock option the same year of the divorce, he gets a stock option. How much does she get? What does the community get? Employed while married, 5 years. Employed that it took to get the stock option, 10. So community property gets 5/10 equals 1/2 of the value of the stock option. And the value of the stock option is you buy the stock at $1, you sell it at $100, $99. Okay, she gets half of that increase, right? Okay.
Quick question.
Mhm.
So you're saying again, at the time of keeping it simple, time of divorce, it's at 10 years.
Mm-hmm.
So wouldn't there be a disincentive for anybody to pursue a stock option if you're going to have to?
No, it's not pursuing. It's if it's a reward for past services.
Oh, so it's automatically just given?
Yeah. If the company says congratulations because you worked here in the past.
Okay.
Now, there is another formula if it's pursuing. If the stock option is not congratulations you worked here, it's hey, welcome to the firm. If you stick with us for 10 years and don't bail, if you stick with us for 10 years, then at the end of 10 years you're going to get a stock option. If it's a signing incentive to stay there, it's a different formula. Okay? So this is a reward. What if it's a incentive to stick around? If the stock option is an incentive, then the formula is years from the date the stock option was granted to the end of the economic community divided by years of the date stock option was granted till it can be exercised. So community property has pro rata share equal to years from granting stock option to end of economic community. Now, typically that would be divorce, but it doesn't have to be in the case of separation. That's why you don't say till divorce, it's till the economic community ends, till one of them moves out. And to have the end of the economic community, it has to be both. Physically moving out of the house, okay, and the intent not to resume the marriage. By the way, that's a relatively new rule, till about 3 years ago. It used to be, well, I don't want it, I'm not married, I don't care, I don't want to be married to you anymore, but I can't afford rent anywhere else. So here's my side of the house, here's your side of the house. And that used to be considered good enough to end the economic community, but the court said no. No, you actually have to move out. So years from granting stock option to the end of the economic community divided by years from granting. By the way, when is it granted? Granted means when you sign up, when they tell you, hey, if you stick around, you'll get this. The sign-up time. When the incentive is told you and it makes you want to stick around. That's what granting means. Okay? Years from granting the stock option till pretty much separation or divorce, or years from granted to divided by years from granted to when stock option can be exercised. Okay? So, an example. Right when he signs up with the firm, they say, congratulations, welcome to your new job. If you stay here for 10 years, we will give you a stock option. Okay? So, at the marriage, so he works there for 5 years, then he gets married, works there for another 5 years, but here is when it's granted. Stock option granted. That means, hey, the incentive is presented to him at the beginning. Okay? Works for another 5 years during the marriage. Okay? And then there's divorce. Okay? If you stay here for 10 years. So, the years from granting to the end of the economic community is 10 years. So, even if he's not married then. Divided by years from granting to when it can be exercised. 10 years. That doesn't make sense. I'm off something.
Is it granted 5 years later, so 10 over 15?
No. Let's say he's married for 5 years and then the divorce is immediate. From granting till the end of the economic community, and then from granting till it can be exercised. If they're exactly the same, then the community has the entire, but that wouldn't make sense because you worked at it before. Well, I know that's the formula. I think I'm applying it wrong though. Yeah. Stock option, if it's an incentive, years from granting it till the end, and divided by years from granting it till when you can get it. So assuming, let's say the divorce was at the 10-year mark, but he can't exercise it till he worked there for 20 years. So he works there for another 10 years. Okay? So the community gets years from granting till the end of the economic community, 20 years divided by 10 years divided by 20. Okay? So then the community gets one half of the CP, of the stock option value. I guess the rule is if it's an incentive, the community and the stock option is exercisable right when the divorce happens, then the community gets all of it, which means it's just split evenly. If it's not very clear, look up stock options. We're going to move on. Stock options as incentives. Okay. What about business goodwill? The goodwill of a, yes? I think it's like, I don't know, but I would imagine it's like pension where you force exercise. If you can't exercise them, you have to. You sell it and then you divide up the profit. You buy the stock, you sell it immediately, you divide up the profit. Goodwill. The goodwill of a professional practice is community property. What does goodwill mean? Goodwill is the qualities that generate income beyond labor and assets. So you're going to have a professional practice if you become a solo attorney. What is the goodwill? People that know you, people that trust you, right? That is a quality of the professional practice that generates income. Guess what? The goodwill is also a community asset. So you have to value the goodwill and divide up the value. How do you do that? You hire experts. Right? So, George Small Law, right, versus George Small Law, and everybody knows him, and oh yeah, go there, right? That's goodwill. So then you'd hire experts to say, okay, what is the value added besides some random company, and because people know him and trust him, right? Okay, educational expenses. A professional degree is not community property. Your ex does not have to have half your JD. Professional degree is not community property, but community can be reimbursed for cost of education if it enhanced the student's separate property, earning capacity. If the cost of the education enhanced the student spouse's earning capacity. One more time. The professional degree is not separate property, but the community can be reimbursed for the cost of education if it enhanced the separate spouse's earning capacity. There was the, kind of the joke of she'll put you through law school, and as soon as you graduate, then divorce. Right? People would do that. So, well, she put you through law school.
So stay married for 10 years, and then get divorced. My friend actually did that. She got a PhD from USC. At the 10-year mark, she was out. I mean, it's expensive, right?
Okay, so that is the exception. All right, the spouse already, so the non-student spouse can be reimbursed for, right, the community gets reimbursed, which means they get half of the tuition, basically. The non-student spouse can be reimbursed unless the non-student spouse already substantially benefited. And it doesn't have to be 10 years, but there's a presumption that at 10 years, they've already substantially benefited.
Oh, wow.
Okay? But it doesn't have to be. It could be earlier, but then you have to prove it. Whereas if you wait 10 years, you don't have anything to prove.
Maybe that's what her lawyer told her.
Just wait 10 years. And the other exception is if the other spouse also received a community-funded education. If the other spouse also got their tuition paid from the community, then there's no reimbursement. Okay, and they don't compare then, well, you went to USC, you went to UCLA, this costs more. No. If they both got professional degrees, there's no reimbursement either way. If only one of them did, the non-student spouse gets reimbursed unless they've already benefited, and the presumption is after 10 years you've already benefited. That presumption doesn't exist before, but you can prove it. Okay, tort liability. A tort victim, what does a tort victim get? Somebody it's not. What if there's a third-party tort victim, not one of the spouses, somebody else? A tort victim may reach what? The tortfeasor's spouse's separate property and the community property.
But as a last resort, the community property, right?
Yeah, if that depends what the activity that gave rise to the tort was for. Sure. The tortfeasor's spouse's separate property and the community property. Now, which do you go after first depends on what the activity was for. If the activity that gave rise to the liability was for the benefit of the community, driving your kids to the soccer game, and you got in an accident, then where do you go first? What's the first pocket you go into? The victim recovers first from community, then from separate. Okay? If the activity that gave rise to the liability was not for the benefit of the community, driving to see your girlfriend, the victim recovers first from the tortfeasor's separate property, then for the community property. And if it's like, well, he got drunk at the bar and he was driving home, was it for the benefit of the community?
Yeah, he needed sanity.
So that's what he would argue, right? So that's the thing, you would argue, well, he worked there. Aha, all right. The victim may not recover, so you get from both the tortfeasor spouse is separate and the community. Which pocket is off limits? The non-tortfeasor spouse is separate. That's off limits. The victim of the tort can never recover from the innocent spouse's separate property.
Yeah.
Makes sense. You recover from the community, you recover from the guilty, the liable spouse's separate, and from the community. And which first depends on what they were doing. Okay. Now, what if one spouse recovers for the torts of another? Do you remember that in torts class where you have spouses suing each other? It used to be presumptively illegal, but now if there's husband and wife in the car, wife is driving, they get in an accident. Who does the husband have to sue? His wife.
Yeah.
He has to sue his wife. Okay? Honey, I love you, but I got to argue that you were negligent. Right?
You're saying she was driving?
Yeah, she's driving, there's an accident. Husband says,
But she's okay with it because
yeah,
it's gonna go back to them.
exactly. So if one spouse recovers for the torts of another, the recovery of the injured spouse is the spouse's separate property. So he sues her to get the insurance money.
Right.
The money he gets from insurance is only his. It's not community property. If one spouse recovers from the torts of a third party, then the recovery is community property. And it's treated as community property on death. So if one spouse recovers from the torts of a third party, husband is by himself in the car, he gets in an accident with the third party who's found liable, he gets the judgment. What does he do with that money? Is it community or separate? It's community. If the husband dies from that on death, that award is community property, which means goes to the wife automatically, not to his kids from the prior marriage, right? The only time this matters really is when there's kids from a prior marriage, on death, right? Because that's where I'm saying that's why community property bleeds into so many other areas. You have to know community property and wills and trusts and do them both together. If there's kids from a prior marriage, what do they? And there's no will. What do they get? They get this. They get. If there's one child, they get half the separate property, and the spouse gets half the separate property and all the community. If there's two kids, they get 2/3 of the separate property. The spouse gets 1/3 of the separate property and all the community. So that when we get to wills and trusts, we'll talk about that. But on death of the injured spouse, the tort award is counted as community property. However, on divorce, the entirety is awarded to the injured spouse, unless justice requires otherwise. When would justice require otherwise? Let's say she took care of him for the past 10 years. Okay? Then she would get a proportional share of the injury award.
Maybe it took 10 years to settle and she'd been caring for him.
Yeah.
His injuries.
Yeah.
Okay.
Management rights. Management rights over property. The general rule is each spouse has equal rights of management and control. Remember, that does not include the right to give stuff away. It's the right to sell, to improve, okay? Each spouse has equal rights of management and control over all of the community property. And each spouse therefore has the power to buy or sell community property, to contract debt without the other spouse's joinder or consent. So one spouse can sell the kitchen table without the other spouse consenting, but they can't give it away. Okay? Since each spouse has equal rights of management and control, they can buy, they can sell, they can contract debt, right? But they, without the other spouse's joint or consent. Exception number 1 and exception number 2. There's going to be 2 exceptions. Exception number 1, personal belongings. One spouse cannot encumber or sell personal property used in the family dwelling. So no, I was wrong. They cannot sell the kitchen table. They cannot encumber or sell personal property used in the family dwelling. Can they sell stuff that's been in storage forever? Yes. They just can't, they can't take stuff out of the house and sell it without the written consent of the other spouse. Now, on the bar, if this comes up, of course, the other spouse didn't give the written consent, so what is the remedy? The transaction is voidable by the non-consenting spouse at any time. Okay. And secondly is a business. Personal property used in businesses. One spouse, the second exception, one spouse cannot encumber or sell substantially all of the personal property used in a community property business. Shelves, computers, desks. The non-managing spouse of that business can't go into the warehouse and sell off the desks and computers. Okay?
Can you go?
Sure.
Start again.
Sure. The general rule and then the 2 exceptions. The general rule is each spouse has equal rights of management and control over all of the community property with the power to buy, to sell community property, and to contract debt without the other spouse's joinder or consent. Each spouse can get their credit card without the other spouse signing on. You can buy a car without the other spouse agreeing to it. Right? You can you can sell off community property without the other spouse agreeing to it. Exception, however, and of course the bar tests exceptions. The exception is personal belongings, stuff in the house. One spouse cannot encumber or sell personal property used in family dwelling without the written consent of the other spouse. The second exception is businesses. One spouse cannot encumber means gets a loan on, like put it up for collateral, or sell substantially all of personal property used in a business. Think computers, desks, hardware. Okay, without the written notice, without the written consent, sorry, here it's written notice to the other spouse. So stuff out of the house, the other spouse has to say, I agree. Stuff in a business, the selling spouse just has to give notice. Doesn't have to get their agreement, just has to write them a letter saying, I'm going to do this. Without written notice to the other spouse. But in this case, when you're selling business stuff, the transaction is not voidable by the non-notified spouse. If the other spouse was not notified, the transaction is not voidable. Whereas with personal belongings, if the other spouse did not consent, they can void it. With business, they're supposed to give written notice, but the transaction is not voidable by the other spouse. What do you get then? If you can't void the transaction, what do you get? Well, you get damages, basically.
May I ask a question for
Huh?
clarification? What's the distinction between, I feel like I should know this, but I don't, or I'm confused. What's the distinction between like during marriage or after marriage? I have something that says if the cause of action arose before marriage, after marriage, or after permanent separation, and that the award is separate property of the injured spouse, versus like.
Oh, you're talking about torts now. That's under tort liability.
No community property for the personal injury award and settlement?
Yeah.
Yeah.
So remedy for torts, right? Personal injury settlement.
Yeah.
If the cause of action arose, one more time.
The distinction between if the cause of action arose during marriage, personal injury awards and settlements are CP, versus if the cause of action arose either before marriage, after marriage, or after permanent separation. I guess I'm not understanding the distinction between during marriage or after marriage.
Cause of action means when they got injured.
Right.
If they got injured during the marriage, the award is going to be community property.
Right.
If they got injured before the marriage or after the marriage, right, after the divorce, then they got injured.
Sorry, wow.
Yeah.
Got it.
Okay, but that rule is a little too, it's not fine enough
Okay.
because it's not that simple. If they got injured during the marriage, it's community property and it's treated so on death. but it's treated as separate property on divorce.
Got it, okay, thank you.
It's given to the injured spouse unless justice so requires. So even if he got injured during the marriage
Okay,
and they got a big award, the general rule is the injured spouse gets it all.
right,
Unless justice so requires, which probably would be if the other spouse took care of them.
okay, got it. I follow. Thank you.
Yeah. Okay, realty transfer, transfer of real property. So for transfer of personal property, a spouse can act alone.
Okay.
For transfer of real property, they must act together.
That's even with the BFP, right?
Um,
Like even if it's a BFP, the
well, we're going to get to that right here. So both spouses must join in an instrument selling, conveying, or encumbering. Okay, real property. Both spouses must join in an instrument that is sells, conveys, right, gives it away, or gets a loan on. A mortgage, encumbering real property. What's accepted? What is the exception? A spouse can act individually in leasing a property for less than 1 year. And leasing interest in property, for less than a year. So if you want to rent out the back house for 9 months, a spouse can act on their own.
Is that because it's?
Because it's not statute of frauds. Remember, statute of frauds is an interest more greater than a year, which includes renting for more than a year, right? So a spouse must join, both spouses must join if there is selling, conveying, encumbering, and renting for more than a year. Okay? The non-consenting spouse but now you have a statute of limitations on when you can void it. Remember before, for stuff sold out of the house, the non-consenting spouse, there's basically no statute of limitations. The non-consenting spouse can void at any time. Here, for real estate transfers, the non-consenting spouse can only void within 1 year. If the transferee is a bona fide purchaser, if the transferee didn't know that the other spouse didn't agree, then they have 1 year. Okay? And how does the non-consenting spouse void the transfer? Demonstrating there was no consent to the transfer. And then the bona fide purchaser must return the purchase price. Well, they have to return the purchase price to the purchaser, obviously. They get the property back and they give the... Okay. What if the transferee is not a bona fide purchaser? He knew the husband was going behind the wife's back.
no recourse.
There is no statute of limitations. Then the wife can get it back at any time.
Wait, say it one more time?
So the 1 year statute of limitations on getting back real estate that you never agreed to give away is 1 year if the recipient, the purchaser, was a bona fide purchaser. If the transferee is not a bona fide purchaser, by the way, there's 2 years to not be two ways to not be a bona fide purchaser. Either you knew something was fishy, or you weren't a purchaser, you're a donee. Right?
Okay, right.
If it was a gift to you, there's no statute of limitations. And if you bought it, but you knew something was fishy, there's also no statute of limitations. The non-consenting spouse can get it back by demonstrating no consent to the transfer and must return the purchase price. By the way, that places the burden of proof on the non-consenting spouse to prove I didn't consent.
Is that a hard burden?
I don't know, but it's kind of awkward. How do you prove that you didn't? The only other area of law that's kind of like that I can think of is rape, because not consenting is the element, right? It's an element of it. So the prosecution has to prove the victim did not consent. As opposed to any other area of a tort where consent is a defense, right? For here, it's not a defense, it's an element. Lack of consent is an element to getting your property back. Okay, neither spouse can encumber half interest in real community property. And real property, that's community property. Neither spouse can encumber just a half interest. In other words, can you get, let's say your house is, when most people in California buy a house, they usually get it as community property with right of survivorship. Can you go to the bank and say, I want a mortgage just on my community property half? No. You encumber the whole thing or not at all. Okay? you can only the entire interest can be encumbered. Okay? The exception to this is a family attorney real property lien. A family attorney real property lien. Where the spouse can unilaterally encumber half interest in real community property to pay the attorney in a divorce case. Right? The only exception to you can't get a mortgage on your half interest in community property is where you hire an attorney and you say, I can't pay you now, but I can get a mortgage on my half interest. Yeah.
Couldn't a spouse break the joint tenancy and change the status to tenants in common?
If it's titled in joint tenancy. The problem is that even if it's titled in joint tenancy, if you bought it during the marriage, it's still community property.
Okay.
Right? So, yes, they could. They could change if they were to break the tenancy, sever the interest. But how do you sever it? You sell it. Right? You can't. The way to sever the interest is to give away your interest to somebody else. Because if you have a joint tenancy, we talked about this in property. If you have a joint tenancy and you write a will, the joint tenancy will trump the will. Right? So you sever a joint tenancy by selling your interest. And then the new guy comes in, and now they're tenants in common with the old person. Okay. So the only exception to encumbering your half interest is on a family law attorney putting a real property lien to pay for their services. Okay. Premarital debt. People get into marriage already owing a bunch of money. What can the creditor reach? The creditor can reach community property to pay a spouse's premarital debt. The general rule is a creditor. So even if all the credit card debt was incurred before the marriage, what can the collections company go after? Can they go after community property? Can they go after the wages? Yes. Unless the non-debtor spouse places earnings in a separate account that the debtor spouse cannot access and does not commingle the funds. Okay? If there's a couple that they go into the marriage, one of them owes $20,000, $50,000 in credit card debt, and then they get married, what's a smart thing to do?
Get separate bank accounts.
Get separate bank accounts. The non-debtor spouse puts all of their money into a separate bank account that does not name her as joint owner. Okay? So that the creditors cannot put a lien on that account.
Right.
Yeah.
What about student loans?
Same thing. It's premarital debt.
Same thing? Okay.
Yeah.
Or you can run a credit report.
I'm a whole package. You get my loans.
I was gonna say, no, they're gonna have to run on me.
Run a credit report. That's interesting. Well, a lot of people do that. Police, if you want to be a sheriff or police, they run a credit report. Because your faithfulness with money is a pretty good indicator of how faithful you're going to be on the job. Can you be trusted to pay back your money? Then I can trust you to go to work on time. Marital debt. A creditor can reach, so what about debt incurred during the marriage? The creditor can reach community property to pay a spouse's debt incurred during the marriage, because both spouses have equal management power, and either spouse can enter into contracts and incur debts. I'll say that one more time. Creditor can reach community property to pay a spouse's debt incurred during the marriage, because spouses have equal management power, and either spouse can enter into contracts and incur debts. So marital debts. What about marital debts for necessities? Okay, that are paid during the marriage. Creditors can reach a spouse's separate property. So if it's just marital debt, you can only reach community property. When can you go after a spouse's separate property? If it's for necessities. So, like to pay medical bills. Okay. Hospital collections, they can go after separate property too, not just community property. Right. To pay medical bills, for food, if you run up a credit card for food. But on the bar, if they do this on the bar, it'd be obvious stuff like medical bills. It's not going to be, well, he bought a golf cart. Well, it's probably not a necessity, so they can only reach community property, not separate property. He bought a car. Well, it depends. Did he live in Orange County? It's kind of a necessity, I guess. Well, you can take the bus everywhere, but it'd take you 3 times as long to go to work. Right, so you would argue. What duty do you have to pay for debts incurred after marriage? After a divorce, a creditor cannot reach community property awarded to a spouse unless that spouse incurred the debt. They were the signatory on the loan, or was assigned the debt by the court. One more time. After divorce, a creditor cannot reach community property awarded to a spouse. So they rack up debt during the marriage. The stress of that debt leads to a divorce. The spouse, the non-debtor spouse that didn't rack up the debt, they still get half the assets. Can the creditors go after the non-debtor spouse? No, unless the court assigned the debt to that spouse. Remember, courts can assign debt even to a non-debtor spouse, the one who didn't actually sign the loan, depending on the disparity in income potential. QCP, quasi-community property. We're almost done. We're going to be out of here early today. I'm on page 10 out of 12. No, I'm on the last page. I'm on page 10. We're going to be out of here really early. Quasi-community property. Quasi-community property is property acquired by a married couple while domiciled in another state, which would have been community property had the couple been domiciled in California.
So they're in Florida.
Yes. Okay? So quasi-community property is a counterfactual. What would have happened if? Okay? Sure. Quasi-community property is property acquired by a married couple. So it's property acquired during marriage, but the couple is domiciled in another state. The couple married in Florida still live in Florida. Okay? That property would have been community property had the couple been domiciled in California. When does this matter? When couples move into California.
Yes.
Right? That's what we care about.
It's when they file here.
Yeah.
Otherwise, it's irrelevant.
Yeah, exactly. So couples move here and file, but they acquired land and property elsewhere. Okay. So QCP. The reason we care is because regular CP is treated the same on divorce and death. What about quasi-community property? There's 2 different rules for divorce or death. That's why we care. That's why we're saying, that's why we're calling it a different term, because there's a different rule between divorce and death. On divorce, QCP is treated just like CP. It's divided equally. So remember that case where the guy shows up in California over the weekend to hang out with his daughters and the wife serves him the papers? And he was there for the weekend?
That counts.
Yeah, that counts, right? Because it's personal service, right? That's the tagging jurisdiction in CP and Civ Pro, okay? But all the property was in New York. The property was gained, bought in New York, gained in New York, appreciated in New York. Now what? Doesn't matter. It's treated like community property on divorce.
Because he was served in California.
Yes.
And then the people that are married in a state that recognizes a common law marriage, let's just say if it's like Georgia,
Mhm.
and they come here, we would then recognize their marriage as quasi-community property, correct?
That I don't know.
I think we recognize common law marriages that are outside.
You probably have to because of constitutional requirements to full faith and credit.
Yeah.
But
Because that's a distinction too, because other jurisdictions have common law marriage.
yes. Yeah. I don't know that they'd go that deep into the weeds on the bar. I don't think they'd do that. That's like too many layers of... You could look it up. The bar used to be really much more complicated. Since 2013, 2014, it used to be like look at like super long all the way down the page, like 5 paragraphs.
Really?
Yeah, they were really hard and really complicated. They've gotten to be a lot more general and easy.
Oh, so looking for essays, would you say how far should we go back?
Well, go back, if you really want to learn the law, go back old stuff because it's like really hard. But realistic, 2013 and so on. Is more realistic of how they're doing it now.
Jeez, okay.
So, but do old stuff for the sake of learning the law and look at how to do it. But likely they're not going to be that hard and complicated anymore.
Okay.
Okay, on death, quasi-community property is treated differently than divorce. On the death of the acquiring spouse, the spouse that bought it, quasi-community property is treated as community property. If the acquiring spouse dies, their QCP is treated as CP. Okay. Again, when does this matter? In blended marriages, where the kids say, well, we get his separate property. No, the second wife gets all of it, like that. If it's CP, second wife gets it all, right?
Yeah.
If it's SP, the kids from the first marriage get half or a third of it. So, the acquiring spouse has testamentary power over 1/2 of the QCP. The acquiring spouse has testamentary power over 1/2 of the quasi-community property, which means that the estate of therefore the estate of the acquiring spouse has a half interest in the acquiring spouse's QCP. And the estate of the non-acquiring spouse also has a half interest. Okay? So, the non-acquiring spouse, however, has no testamentary power over the acquiring spouse's QCP. So, do you remember, for regular community property, both spouses have testamentary power over half of the CP. You can will away half of the community property to whoever you want to. Okay? It doesn't have to be a spouse. But you can only will away half of it. Okay? That's regular community property. QCP, the rule is you can will away half of the QCP if you're the one who bought it, if you were the acquiring spouse. If you were not the acquiring spouse, then you cannot will away at all. You have no testamentary power over the acquiring spouse's QCP. So if the non-acquiring spouse dies first, her will cannot devise any part of the acquiring spouse's QCP. If property is from another state, okay, and it's death issue, if it's divorce, it's easy, just treat it as community property. Now, if it's a divorce issue on the essay, still call it QCP, don't call it community property, but just say it's treated as community property and the rest of the essay you're fine. Ignore any distinctions. You only care where there's a death issue, okay, which would be a crossover community in wills and trusts. If there's a death issue, then think who bought it. The acquiring spouse is allowed to will away that spouse's, his own half interest. The non-acquiring spouse cannot will away the other spouse's QCP. Okay. And if you think about why, because even though we're going to treat it as community property for the sake of divorce, for the sake of death, we still have to respect the non-community property state's laws, right? Okay. Non-marital relations. We are almost done. What if you're just living together? California does not recognize common law marriage, except where recognized in other states. Okay? So yes. California does have to recognize common law marriages from other states, but a non-married couple cannot have community property. So what are they? A non-married couple can only have tenancy in common or a joint tenancy, but they can't have community property. A non-married couple in California cannot have community property. They can only have tenancy in common or a joint tenancy. This is my argument to people. I don't have to get married. It's the love that counts. What do I need a piece of paper for?
Right.
For your protection.
Or they can just do trusts.
Yes, but you have to do something, right? Right, but it's for your protection, because if he takes off, he doesn't owe you a penny because you're not married.
Or if they have life insurance policies with like.
Yeah, but so you have to do something. Yeah. But most people don't. Most people just live together and they don't do anything, and they just figure it's all love that counts. That's all that matters.
Some people are like majorly over the idea of not getting married, but having all their stuff in separate entities.
Yeah, that's.
Unless your boat is not community property.
Yeah. So the division. How do you divide stuff that's not married? The division is determined by contract.
Right, like it's trust.
Yeah. The trust is a contract, right? Life insurance.
Of course.
So the property division is determined by contract. The contract can either be express, written stuff, or it can be implied from conduct.
Which also skips probate, right?
No. Well, a trust would skip probate. Yeah. A trust would, yes, of course. Yeah. So there can be an express written contract. It can also be a implied contract. Hey, I'm going to go to work. You stay home and cook me up great dinners. Okay, great idea, but we're not going to get married. Okay, so that's implied by contract. However, the contract cannot be based on sexual services. We're not going to institutionalize pimping, right? It's determined by contract, but not based on sexual services. It can be based on cleaning the house, on whatever. But okay, a putative spouse. That means somebody who has a subjective belief that he or she is lawfully married. When can you really think you're married but you're not? Well, so are there situations where you can really believe that you're married but you're not?
Of course.
Yeah.
Like they didn't submit.
You never sent the thing to a family member of mine who found out years later.
Yeah.
It's like, oh, whoops, right? Or you you really thought that, it's good enough to go to the chapel and just say your vows to each other.
You didn't know he was married.
Or you didn't know that his prior marriage was never dissolved.
Right, it was still valid.
Yeah. So especially when you're married in another country and the divorce in that other country was never complete. They thought that was complete in Mexico. That was one of the cases in the book. They thought the divorce was complete in Mexico, but it wasn't. So he gets married to another woman in California. He's still married. Right? So the second marriage doesn't count. So the assets, a putative spouse has a subjective belief that he or she is lawfully married. The assets earned during that time when they're a putative spouse is called quasi-marital property. It's not QCP, it's QMP, quasi-marital property. Okay? It's also divided equally on the end of the relationship. You can't say divorce because they were never married. It's divided equally, except where one spouse was a bad faith partner and knew there was no marriage. He knew the divorce was never finalized. But she thought it was. She thought they were really married. Okay? Except where one spouse is a bad faith partner and knew there was no marriage. He convinced her that California does in fact allow common law marriage, right? He is not entitled to half the property earned by the putative spouse's labor. So, a situation where they're both equally dumb, they both really think they're married, you treat quasi-marital property as community property divided equally. What about where one of them is devious and the other one is dumb? The devious does not get the half of the dumb partner's salary. The dumb partner does get all of her salary plus half of the devious one. Okay? So, but the devious one does not get, keeps only half of his and gets none of hers. Okay. Usually the devious one is the putative spouse, putative husband, who tricks him to think, don't worry, honey. Okay. Once a putative spouse becomes aware that there is no marriage, they no longer acquire quasi-marital property. Once they've learned that, at that point it's like divorce or separation. There's no more QMP. Okay, everybody has their own separate property. Okay, they no longer acquire quasi-marital property they are only unmarried cohabitants, and each party, absent a contract, keeps his own earnings. That's all for community property.